Fed and State Committee to order, and we do have quite a few bills this morning. So we'll start with House Bill 2057. And well, first of all, are there any bill introductions? I was not told of any, so moving on to House Bill 2057. It's allowing an alcoholic liquor manufacturer to obtain a drinking establishment license under certain conditions. And Jason, are you online?
Yes, Mr. Chairman.
Could you give us a staff briefing on that, please?
Yes, Mr. Chairman, members of the committee, House Bill 2057 does amend a statute, some statutes in the Club and Drinking Establishment Act to authorize a person who holds a manufacturer's license to obtain one drinking establishment license. Under current law, that is prohibited. The statutes are amended to allow that one drinking establishment license for a manufacturer of alcoholic liquor. There is a proviso, though, on that on page 4, that the licensed premises of the drinking establishment cannot be the same as the licensed premises for the manufacturer, but must be not more than 2 miles from the licensed premises of the manufacturer. So if you have a license to manufacture alcoholic liquor, you can open a drinking establishment license within 2 miles from that premises. Additionally, on page 5 of the bill, you'll note new language that requires the drinking establishment to acquire all of their alcoholic liquor and cereal malt beverage through the 3-tier system, which means they would have to go through the distributor or licensed retailer to obtain the spirits and the beer and the wine that they would sell at the drinking establishment. They cannot acquire it directly from the manufacturer who holds both licenses. The bill will go into effect on July 1st of this year. If enacted, I'd be happy to answer any questions, Mr. Chairman.
Thank you. Are there any questions, Jason? Yes, Senator Falscadeau.
Thank you, Mr. Chairman. Jason, so what was the original reason that this was not required in the first place? And can that licensure or the intent of this bill, can it be the same entity, both the manufacturer and the, thank you, Mr. Chairman.
So the long-standing practice of the liquor statutes is to prevent the same entity from holding licenses at different points of the 3-tier system. We have the manufacturer, then the distribution, and then the retail sale of alcoholic liquor in Kansas. And generally, we prohibited manufacturers from having distributor or retailer licenses and retailers from having manufacturer or distributor license, so that there's this buffer separation among the licensees as the alcohol gets sold and transported from the distilleries and the breweries to the end consumer. In this case, there's an exception being made that if the manufacturer wants a drinking establishment within 2 miles of the manufacturing premises and only one drinking establishment, and that the drinking establishment only get their alcoholic liquor through the 3-tier system, so there's still that buffer going on, then we are going to allow in that one instance the manufacturer to obtain a drinking establishment license and the same entity to hold both licenses concurrently.
Are there any other questions? Thank you, Jason. Our first proponent is Representative Epley. And before we get started with that, we are tight on time, and so we'd like to keep that under 2 minutes. We do have your written testimony, so we do appreciate that. Welcome.
Yes, thank you. Thank you very much, Senator Alley, Chairman Alley, and Vice Senator Chairman Hildebrand, and Ranking D. Falscadeau, and members of the Fed and State Affairs Committee. I really appreciate this brief 2-minute introduction. And I just can't say enough positive things about your assistant. She worked all through the weekend to help me put this together. We are on turnaround. I feel like turning around myself because it's been so fast. And I really can't thank her enough. She's going to have to get some free samples of either Till, Remus, or whatever from one of my local distilleries and to help her out to get through this time. I saw her running around here, and it looks like she needs that. So I feel sorry for it. You have my testimony. This is a long-standing issue that's been percolating here for about 5 years. It actually started with Jerry Henry. He was here before me, and it's taken me, this is the third biennium. I hope the third time's a charm. I've worked carefully with all the stakeholders. Two very important members are here today, and while they're not teed up for testimony, they will affirm that they're in support of this bill. It's been narrowly crafted to support an issue that's going on in my district. I have 2 distillers of spirits, and they both would like to have the ability to have a license within 2 miles of their point of manufacture. So that, again, that's in the bill. It's been narrowly crafted. It flew out of Commerce in the House side, unanimous, and it was passed through the House floor 124-0 about a week and a half ago. So it has the broad support of the House of Representatives. As I conclude, I would ask, please, that you not let this die by bundle. I would ask that we keep it clean, because sometimes when we bundle things, they tend to go away, or they get gutted, or bad things like that happen to them. This is my 5th year, and again, I hope that this is the year when this happens. So again, I appreciate the opportunity to appear before you. You have my testimony, and I'd be happy to stand briefly for any questions. Thank you, Senator Alley.
Thank you. Are there any questions? Seeing none, thank you very much. The next one, remote, is Joe Warren, City of Atchison, by remote. Joe, are you here?
Yes, can you hear me? Thank you.
Yes, we can.
Thank you, Chairman Alley and fellow committee members. Essentially, this is an economic development issue for the City of Atchison. We have, in our area, we have a large distillery here at Atchison, MGP Ingredients, and they manufacture spirits for a lot of companies. And they've started creating their own lines. And so what they've wanted to do is essentially open their own establishment that would allow, essentially them to have their own wares nearby. And Atchison is a community that relies a lot on tourism. We think this could help us quite a bit with the tourism field. And one example that points out the need for this bill to pass is that, Weston, Missouri is just 20 miles to our west. Or to our east, pardon me, and they have their own distillery there, and they're able to have their own tasting rooms, and it draws quite a bit of interest in the tourism industry, the alcohol tourism industry, and we just essentially would like to level the playing field, allow MGP to do the same type of thing, and we think that there's a lot of potential there for the City of Atchison and for Kansas as a whole to benefit from this from the tourism side, and like I said, MGP is a large distiller. They've been good for Kansas, really good for Atchison, and we just appreciate your support in this bill. And I'd be glad to stand for questions. You have my written testimony if you need any more information that I haven't provided.
Okay, well, thank you very much. Is there any questions? Seeing none, thank you very much. The next one is written only by Dave Rendham for MGP Ingredients, and it's written only. Are there any other questions on this bill? If not, we'll close the hearing on 2057, and we'll open the hearing on Senate Bill 256. Changing the start time for Sunday sales of alcoholic liquor from 12 noon to 10 a.m. and removing the restrictions on sale on certain holidays. So, Jason, are you available for a staff briefing?
Yes, Mr. Chairman, members of the committee, Senate Bill 256 amends statutes in both the Liquor Control Act and the Cereal Malt Beverage Act to change the days and times for sales of alcoholic liquor and CMB. Under current law, if a city or county, which does have the option to do so, has expanded the days of sale to include Sundays, they are still restricted to only authorizing those sales from noon to 8 p.m. on Sundays and cannot authorize sales on Easter Sunday, Memorial Day, Independence Day, Labor Day, Thanksgiving, or Christmas. Under the bill, however, the statute that gives them that option, 41-2911, would be amended so that if they were to expand or continue to allow alcoholic liquor or C&B sales on Sundays, those hours would change to 10 a.m. to 8 p.m. And then it would also eliminate the restrictions on sales on Memorial Day, Independence Day, and Labor Day. So the city or county could authorize sales on those 3 holidays as well. The bill also makes an amendment on page 3 to another CMB Act statute. This is in the licensure statute to get a CMB retailer's license, and would require the Board of County Commissioners or the director to issue the CMB retailer's license to any applicant who holds a producer's license, which is a license issued under Liquor Control Act, and provided that the applicant is not disqualified under the provisions of subsection B and C of that statute, then the county would be required to issue a license to the applicant for a CMB retailer's license. The other amendments in Senate Bill 256 simply are to make conforming amendments to other statutes to go along with policy change for the days and times of sales. And the bill will go into effect on July 1st if enacted. If there are any questions, I'd be happy to answer them at this time.
Thank you, Jason. Are there any questions of Jason? Yes, Senator Falscadeau.
Thank you, Mr. Chairman. Jason, we've come a long way from bootleg selling on Sundays, no Sunday sales, to Sunday sales from noon to 8. So basically, this is allowing that sales to be the normal selling time or not?
No, it makes no change to whether or not the municipality has the option. The city or county still has the option to restrict sales on Sundays in their local jurisdiction. What this is doing is if they open up Sunday sales, they can authorize them from 10 a.m. to 8 p.m. rather than currently they're only available from noon to 8 a.m. or 8 p.m. Sorry.
Are there any other questions, Jason? Seeing none, thank you, Jason. First proponent, Amy Campbell with the Kansas Association of Beverage Retailers. Amy?
Thank you, Mr. Chairman. My name is Amy Campbell. I work for the Kansas Association of Beverage Retailers. This bill would allow liquor stores and grocery and convenience stores to sell products earlier on Sundays, as early as 10 a.m. It does require that the ordinance be passed by the local entities, so it still has that local control. And then it separates out the summer holidays altogether. Our members highly respect the cultural nature of Sunday sales, but the issue of Labor Day, Memorial Day, and Independence Day changed drastically when we passed the beer law. So now my members are competing against Walmart and Kroger and Casey's, who are selling on those summer holidays. So we'd just like to pull that out so they would have the ability to sell on those days. Additionally, this legislation has been specifically written to continue to be uniform, and that's very important to us, that we have a uniform state law so that cities and counties, if they wish to opt out, they have a uniform manner to do so. I would also say that there was some interest expressed by the local government folks that they might like to make it so that changing the times on Sundays would not require being subject to protest petition. And if they bring an amendment like that, we would support it. Thank you.
Senator Reichman, did you have a question on?
Well, she answered it. I was wanting to know if the local, they still had local control option, and that was my concern. I want to make sure they still have the option of local control.
Thank you. Our next proponent is Monica Teben of Blackjack Retail Liquor, and she is remote. Monica?
Okay. Thank you, Chairman Larry Allen. And my name is Monica Teben, and I am the owner of Blackjack's Retail Liquor Store in Dodge City, Kansas. And I am speaking to you today in support of SB 256. I'm also a member of the board of directors of the Kansas Association of Beverage Retailers. Last year, when the legislature closed down due to coronavirus, it left Senate Bill 456 stranded. The bill was very important to my store and those who operate in communities that have not elected to adopt Sunday sale ordinances. This is a problem because my store is now directly competing with the grocery stores and convenience stores for the sale of strong beer. I was unable to be open on Memorial Day, Independence Day, and Labor Day to serve my customers, which sends them to Walmart's and other competitors. 2020 was especially tough because Independence Day landed on a Saturday, our biggest sales day of the week. The Sunday sales process makes sense for cities and counties as it reflects community priorities for families and church. However, the summer holidays do not seem to be tied to those community values. If they were, sales would not be allowed in the grocery and convenience stores. I would really appreciate your support to take summer holidays out of the Sunday sales ordinance altogether. I reached out to our city last year and they did not have a problem with the legislation. Passing as Senate Bill 256 would be very helpful to my business and to the others who find themselves in similar situations. Thank you for the opportunity to speak today. And if you come to Dodge City, I will be more than happy to serve you. So thank you so much.
Thank you very much. We appreciate that offer. Is there any questions for Monica? Seeing none, thank you again. The next proponent is Whitney Damon with the Association for Responsible Liquor Laws. Whitney, welcome.
Thank you, Mr. Chairman, members of the committee. Kansas Associations for Responsible Liquor Laws is a retailer group. We have about 25 members spread around the state. Typically, they're the larger retailers in the market areas. But we do join with Amy Campbell's group in support of this legislation. You may recall last year when this bill was brought in January or so, the Kansas City Chiefs were well on their way to Super Bowl victory. That was one of the issues that kind of drove the bill. So kickoff at noon, people didn't want to miss the kickoff. I guess they could, miss the pregame show, but those started about 7 in the morning, I think. But so we supported this bill last session that allowed for retail liquor stores to open up at 10 a.m. We support it again this year. Thank the committee for its consideration.
Thank you. Is there any questions for Whitney? Seeing none, thank you very much. Next proponent is Becky Schwartz of Fuel True, independent energy and convenience store. Becky, are you online? Oh, don't you?
Sure. I'm a little short. It's hard to see.
I was looking up there and I didn't see you up there.
Thank you. I am Becky Schwartz with Fuel True Independent Energy and Convenience Stores. We represent the convenience stores across the state. We also have permission to include in our testimony the Retail Grocers Association, who represent the grocery stores, and as a proponent of 256. And there's not a lot more that I can say that hasn't been said, but our members are consistently having customers that come up as they're filling up their tanks to go to the lake or to go to a family reunion, and they want to grab that 6-pack or whatever to go with them, and we can't sell until noon. So they just want this to help ease their burden and make one stop. So with that, Mr. Chairman, we urge your support, and I'll stand for questions.
Thank you very much. Is there any questions for Becky? Seeing none. We do have a written from Mr. John Goodyear, staff attorney for the League of Kansas Municipalities, and it's in your folder. Are there any other questions? Seeing none, we'll close the hearing on Senate Bill 256 and open the one on 257. $257 allows clubs and drinking establishments to sell beer and cereal malt beverages for the consumption off the licensed premises. And do we have a staff briefing on this?
Yes, Mr. Chairman, members of the committee. Senate Bill 257 amends statutes again in both the Liquor Control Act and the Club and Drinking Establishment Act to authorize the sale of refillable and sealable containers of beer and cereal malt beverage. These are commonly known in the industry as growlers. or potentially squealers, and there's some other names, but growlers are the name most people refer to. Under current law, liquor retail stores under Liquor Control Act are restricted to only selling alcoholic liquor in the original unopened containers, and clubs and drinking establishments are not permitted to sell growlers either. So under Senate Bill 257, we have amendments to both 41-308 and to 41-2653 to allow the sales of these growler containers by those respective licensees. And the sales would be subject to the same conditions. The containers would be restricted to between 32 and 64 fluid ounces. That must have a label affixed that clearly indicates the licensee name and the type of alcoholic beverage contained in the container. It would be limited to beer, domestic beer, and cereal malt beverage for sales in those containers. And then additionally, the club and drinking establishments would be limited to not making such sales after 11 p.m. Alcoholic liquor retailers, of course, by statute, cannot sell after 11 p.m. anyway by statute. With that, I'd be happy to answer any questions that the committee may have.
Thank you. Senator Hildebrand?
Thank you, Mr. Chairman. Jason, just a quick question. Why is it between 32 and 64 ounces and not no more than 64 ounces?
I think because traditionally these containers have been larger than a standard beer bottle of 12 ounces. And so the minimum size typically is 32. The probably more technically correct answer is these are the conditions that are currently in statute for microbreweries to sell these types of products. And that is already in statute at between 32 and 64 fluid ounces. The history of that provision, maybe the director can address if she's attending the meeting or scheduled to testify.
Thank you.
Any other questions? Seeing none, thank you. Amy Campbell with the Kansas Association of Beverage Retailers. Welcome again.
Thank you, Mr. Chairman. Senate Bill 257 was legislation last session in the form of 221. It passed the Senate committee, the Senate, and the House committee, and was left on general orders in the House. This committee last year did respond to our request to put in the 11 p.m. Cutoff time for sales, just to make sure that we weren't doing the one for the road situation in the bars, which we really appreciated. And with that, I would just say that, growlers are traditionally, they're dark glass, they look kind of like a jug, but there are also other formats that are now available, including aluminum cans that can be sealed and that then are obvious if they have been opened once they go out the door. Our liquor stores we have a number of liquor stores across the state that specialize in craft beers, and this is something that they have been wanting for some time. It is a way to feature microbrewery products that are not currently available in 6-packs or 12-packs in our liquor stores. And so we really look forward to the opportunity to feature some of those more unusual or short-term products in our stores. With that, Mr. Chairman, I would be happy to answer questions.
Thank you. Are there any questions? Yes, Senator Eichmann.
Thank you, Mr. Chair. I'm not a drinker, so I don't understand the growlers. So we're talking about when you're in an establishment, then you can have this filled up and you can take it to go? Is that the reason? Otherwise, you'd have to fill it up or throw it away when is that the reason?
So in a liquor store, right now we're limited to the products that come from manufacturers that can and bottle their products and put them on our shelves. The growlers can come in a keg form, and then they fill a jug, a jar, you put the sealed top on it, and then it can go out the door that way. And it's a very popular product across the country. They have all sorts of names for them. Growlers is the most common. Our microbreweries do this today for their products. And if you know anyone who is a craft beer enthusiast, they're very, very popular.
Thank you.
Questions? Senator Hildebrand.
Amy, thank you for your testimony, and I apologize when I get on something that kind of sticks with me a little bit. But going back to the 32 and 64 ounce, I'm assuming the growler is 32 ounce or 64 ounce or somewhere in between there. Is there ever a time that you would never fill that 32 ounce to 32 ounces?
Oh, I don't think so. I mean, you
Would they
have,
ever underfill it?
I mean, well, your price is going to be for the 32 ounce product, so I don't imagine that anybody's going to want a half of one. But you also have the issue, if you put air in the container, then that affects how long that product can last, right? So that wouldn't be considered a very, that could compromise the integrity of the product if you don't package it
I
properly.
was just curious if technically, if that didn't get filled to 32 ounces, it would be not according to statute. So that's why I just asked.
Yeah.
Thank you.
Yeah. And, I think Jason answered that question really well about why it is written this way. It's written this way because this is the standard definition of these products across the country and the way that we sell them in microbreweries. That doesn't mean that we aren't open to amendment if there's a better way to do it.
Thank you. I noticed in your testimony, you've called, and this is for you, sir, growlers, howlers, and crowlers. Is that correct?
That's some of them.
Thank you. We appreciate that. Any other questions for Amy? Seeing none, thank you, Amy.
Thank you.
Brian Davis, he is remote from Davis Retail Liquor. Brian, are you
Good
online?
morning. I'm here. Can you hope you can hear me?
We
Mr.
can.
Chairman, the members of the committee, thanks for having us today. I ran away real quick to grab. If you can see this can, this is a crowler. It's 32 ounces and it comes empty and they reseal it. This is a growler and it's 64 ounces. Top comes off and then we would reseal it with tape. Sorry about that. It was a quick run for me downstairs. But again, thanks for the opportunity to allow me to speak today about Senate Bill 257. I am the current president of the Kansas Association of Beverage Retailers. I also operate Davis Liquor here in Wichita. I'll make it quick, real quick here. Following Amy up, she answers all the good questions. So selling crowlers to customers for consumption away from a licensed premises is a natural role for us as retail liquor stores. This gives us a chance to sell products that we're not going to be able to get. One of them I showed you was Manhattan Brewing Company. They do not put their product in cans yet for us to sell, but I can buy a keg and put it in a store and refill crowlers and growlers and howlers and all those good things for customers as they wish. So it not only does it give us a chance to sell items that we wouldn't be able to have, it also gives a chance for microbreweries to get their product in the hands of other customers outside of their general area. Again, using Manhattan as a reference, people go up there all the time. They have a chance to be able to buy that product while they're here. New opportunities for us in this industry since the change of the law is very important for us retailers, and we're eager to see this put into implementation by in 2021, since we've been sitting on it for a little while now. Again, we appreciate the support of this committee. If you have any questions, I'm here to answer what I can, and Amy's there also. So thank you.
Thank you, Brian. Are there any questions for Brian? Seeing none, thank you very much. Our next proponent is Scott Snyder, Kansas Restaurant and Hospitality Association. Scott, welcome.
Thank you, Mr. Chair, members of the committee. I appreciate Amy and her association bringing this bill, as I've had a pretty busy session on some other things. Originally, 221 was introduced 2 years ago to allow drinking establishments to do what microbrews are allowed to do and sell by the growler or the crowler, whatever they are. Because of innovative ideas like the Brew Bank here in Topeka, Yardbirds in Kansas City, the drinking establishments were trying to sell Kansas craft beer, and they thought that if they could move that the same way that a microbrew could through a growler, that would actually help Kansas businesses along with other national brands also. So along the way, the retail liquor stores wanted to be a part of it also, so that's easy for us, of course. The more the merrier on that one. And so last year, I did have a moment of pause when COVID hit and our guys had open containers, kegs. The beer wholesalers thank goodness we're able to take some of that product back, but some of the product was stranded. We had a stranded investment, and the city of Wichita sent our folks and LDF a notice that we couldn't even dump our beer. We couldn't sell it, nor could we get rid of it. So we're in a bind, and I think, and I thought back to Senate Bill 221 would have been helpful in that moment as a way to move product in a little more efficient way. But I appreciate the committee taking this up and supporting it, and I'll stand for any questions if you had any.
Thank you. Are there any questions, Scott? Seeing none, thank you very much. We do have a neutral, and welcome Director Debbie Beavers with the Alcoholic Beverage Control Division.
Good morning, Mr. Chairman, members of the committee. My name is Debbie Beavers, and I'm the ABC Director. Thank you for the opportunity to testify. We are neutral. ABC did overlook a couple of technical suggestions that we feel that need to be fixed to make this bill go forward. The first one is KSA 41718 prohibits liquor stores from refilling containers and restricts them to selling in the original container. That language is contradictory, and in my written testimony, I provided some language that would fix that. Similarly, in the Club and Drinking Establishment Act, KSA 412658 also has a similar prohibition, and we've provided language for that in my testimony as well. With that, Mr. Chairman, I'll be happy to answer any questions that you have.
Thank you very much. Are there any questions for Director? Seeing none, thank you very much. Are there any other questions on Senate Bill 257? Seeing none, we'll close the hearing on Senate Bill 257 and open the hearing on House Bill 2138. House Bill 2138 is club drinking establishment license or liquor license eligibility. The spouse is the law enforcement officer in another county, and we do have a staff briefing, we hope.
Yes, Mr. Chairman, members of the committee, House Bill 2138 amends one statute, 41-311, which provides restrictions on who can obtain a license under the Liquor Control Act. Currently, any person who is a law enforcement officer or whose spouse is a law enforcement officer is prohibited from obtaining a license under the Act. House Bill 2138 would amend that so that if the spouse was not otherwise prohibited from obtaining a license other than their employment as a law enforcement official, then the person can still get a liquor license under the Liquor Control Act. So your spouse could be a law enforcement officer. And then since the Club and Drinking Establishment Act relies on the provisions of 41-311 for restrictions under the Club and Drinking Establishment Act for licenses issued under that act, this exception would also apply for those licenses issued under the Club and Drinking Establishment Act. This bill, unlike the other ones today, would go into effect on publication in the Kansas Register. So the effective date would most likely be before July 1st of this year if it's enacted. And with that, I'd be happy to answer any questions.
Thank you, Jason. Are there any questions for Jason? Seeing none, our first proponent is Jennifer Wollner, Dirty Girls Adventures, LLC. Jennifer, welcome.
Good morning. Thank you, Mr. Chairman. Thank you, Senators, for inviting me today. My name is Jennifer Warner. I am one of the co-owners of Dirty Girl Adventures. My business partner and I, Denise, have been working to take people outdoors for 8 years. 2 years ago, we purchased some property in Noto here in Topeka. One of the great things about that property is that it has an outdoor courtyard. So Denise and I have been able to engage people in some outdoor activities. We focus on health and wellness as well as having fun. So music is fun, beer is fun, as I think we've established today. But when Denise and I applied for our liquor license for our establishment, we found that we weren't eligible because Denise is married to a law enforcement officer. So we would very much appreciate the removal of that regulation from the regulations in the state. And I'm happy to answer any questions.
Thank you very much. Are there any questions for Denise? Or Jennifer, excuse me?
Yeah.
Any questions? Yes, Senator Falscadeau.
Thank you, Mr. Chairman. So what, either for you or Jason, so what was the original reason that if you were married to a law enforcement individual, you couldn't get a license?
I'll let Jason answer that.
Mr. Chairman, members of the committee, there's a general prohibition against anybody who is a member of a governing body of a municipality or a law enforcement official from obtaining a license. And I believe it's because the local government units are involved in the enforcement of the liquor statutes and the liquor code. They work with ABC, and so it prevents a conflict of interest for persons who are either in the governing body or law enforcement to hold a license.
Any other questions? Seeing none, thank you very much for being here today.
Thank you.
Are there any other questions on Senate Bill 2130 or House Bill 2138? Yes.
Thank you, Mr. Chair. Has this ever come up in the past? This is my first foray into federal and state affairs. Has this come up before?
Refer to Jason on that.
Mr. Chairman, members of the committee, we have had this legislation in years past to create an exception for this. I think this is the second or third year now that we've had this legislation to address this issue on spousal law enforcement officers.
May I ask another question? Has it ever been amended to ask that the exemption be provided but not in the county that the officer works in or is employed by?
Yes, we have had the debate in past years over limiting the exception so that the spouse has to be a law enforcement officer in a county other than the county in which the licensed premises would be located. That has been a limitation that's been discussed in the past.
Thank you.
Okay. Any other questions? Seeing no further questions, we will close the hearing on House Bill 2138 and open the hearing on House Bill 2212. House Bill 2212 eliminates the Kansas residency requirements for various liquor licensing. And Jason, could you give us a briefing on that, please?
Yes, Mr. Chairman, members of the committee, House Bill 2212 addresses the issue of requiring an applicant to be a resident of Kansas and to be a resident for a certain amount of time in Kansas in order to obtain a license under the Liquor Control Act or the Club and Drinking Establishment Act, or even the Cereal Malt Beverage Act. Back in 2019, the U.S. Supreme Court issued a decision in Tennessee Wine and Spirits Retailers Association case where the court held that Tennessee's similar statutory residency requirement was unconstitutional as a violation of the federal Constitution's Commerce Clause. Therefore, because Kansas's residency requirement is very similar, House Bill 2212 addresses that issue by striking the residency requirements in the applicable regulatory acts. And so each one of the acts is amended throughout the bill, as you'll see, to strike that residency requirement. There is a provision on pages 4 and 5 that you'll notice that if the applicant is a non-resident in Kansas, then they must appoint a citizen of the United States who is a resident of Kansas to be their resident agent for purposes of service of process. So they acknowledge jurisdiction of the state of Kansas and the legal proceedings The bill will go into effect on July 1st of this year, and I'd be happy to answer any questions.
Thank you very much, Jason. Are there any other questions? Yeah. Senator Reichman.
Thank you, Mr. Chair. What's the reason for a residency requirement in the first place? Do you know?
It's been a long standing requirement in Kansas liquor law to be a resident in Kansas. I would probably defer to the director of ABC as to the primary purpose behind it, as they have the experience in enforcing that provision. I'll let her address that question. She probably has more knowledge about the purpose behind it.
Questions? Thank you. We'll move on to Director Debbie Beavers with the ABC. Director Beavers.
Thank you, Mr. Chairman, members of the committee. My name is Debbie Beavers. I'm the ABC Director. Thank you for the opportunity to testify in favor of this bill. Along with my testimony, you should have a copy of the Kansas Attorney General's Opinion 2020-11. I did also provide a PDF copy of the U.S. Supreme Court decision for your reference regarding this bill. ABC did bring this bill forward as a result of that United States Supreme Court decision. Tennessee law required an applicant to be a resident for 2 years to get a retailer's license, and then to be a resident for 10 years to renew that license. The Tennessee Attorney General had issued an opinion finding that residency requirement to be unconstitutional. And as a result, the Tennessee ABC was following the AG's opinion and not enforcing the residency requirement when they were issuing licenses. Subsequently, the Tennessee Wine and Spirits Retailers Association then sued the Tennessee ABC to enforce the residency requirement and prevent the licenses from being issued. Ultimately, after several appeals, it ended up in the United States Supreme Court, and they did rule that that residency requirement was unconstitutional and violated the Dormant Commerce Clause by favoring the in-state over out-of-state interests with no justifying legitimate purpose. So ABC, as you can imagine, was aware of this and followed this case closely, knowing that we could have a similar issue here. In Kansas, the law requires nearly every license type to have, for liquor, to have some type of residency requirement. We think the original intent of this residency requirement was allowing local knowledge and control of licensees by only issuing licenses to established upstanding local residents and entities, so that would ensure easy access to the licensee for jurisdiction purposes, and also make sure that ABC can serve citations, orders, etc. on a licensee in Kansas. So last December, the Kansas Attorney General published the opinion 2020-11, which did opine that the residency requirements in Kansas were similarly unconstitutional. So in order to prevent a similar situation in Kansas, this bill does the following things. It does remove any residency language throughout the Liquor Control Act, the Club and Drinking Establishment Act, and the Cereal Malt Beverage Act. It also requires the appointment of a process agent who is a United States citizen and a resident of Kansas if the applicant is not a resident of this state. It also changes shall to may for the director's duty to get fingerprints on out-of-state applicants. And it removes the requirement for an out-of-state entity to domesticate their company. So the ABC believes that this bill is necessary, and we're taking a proactive approach. What happened in Tennessee demonstrates the importance of this bill. Without this change, frankly, the Kansas ABC is really in a bind, and we could be sued in two different ways. First, if the application is denied because of non-residency, or second, if ABC does not enforce the residency requirement and issues the licenses to non-residents. So we are also aware of concern in the industry that this could open the door for some other changes in liquor laws. And because of that, we do respectfully request that this bill be kept as written. Thank you, Mr. Chairman. I'll be happy to stand for any questions.
Thank you. Director, are there any questions? Seeing none, thank you very much. Our next proponent, Amy Campbell with the Kansas Association of Beverage Retailers. Welcome again.
Thank you, Mr. Chairman. The director did an excellent job of explaining this bill, and we appreciate the ABC bringing forward the legislation. I would say that our members believe that residency has been an extremely effective tool for the oversight and inexpensive regulation of the liquor industry in Kansas. We are sorry to see the residency portion go. However, the results of the case are clear, and we have to remove this from our statutes. So we support that in happening. Every change to our statutes does have an effect on our members and their business viability. Please remember that our liquor store owners are still dealing with the aftermath of the 2019 beer compromise, of which we were partners, but we were aware that it would have an impact on our members. One of those impacts has been that since 2017, we are down 35 liquor stores in the state. Our retailers support the business-friendly regulation of the sale of spirits, wine, and beer to the public, and we asked that our statutes continue to require a fair and even playing field for licensees by retaining the balance of current requirements for off-premise retailers. Some of you may remember the ABC's report to you earlier this session, in which she talked about the difficulty in regulating the out-of-state wine shippers that, not just wine, entities that would ship alcohol into this state regardless of what our state laws are. And we think that that's a perfect example of how difficult it is to regulate an entity if they do not live here. All the more important to remain the brick and mortar requirement for the license location being in the state of Kansas. It's the role of the legislature to establish the statutes regulating alcoholic products that is provided by the U.S. Constitution. We think that every change to the Liquor Control Act should clearly mitigate health and safety risks that are posed by alcohol, whether that's underage sales, the being able to trace where the product comes from, and many other issues. We're acutely aware of the cost to our communities and families when illegal activities occur under the radar. We appreciate the division of ABC and the director. We'll continue to work with them and we hope that you as a legislature will continue to provide them with the resources that they need to enforce an even playing field in the liquor industry. With that, Mr. Chairman, I just want to be clear that any attempt to expand licensure to corporations, chains, or big box stores would be viewed by our members as a violation of the compromise that was placed before the Kansas legislature in 2017. That agreement assures that they will not pursue legislation to expand the products they sell beyond beer up to 6% alcohol by volume for 10 years. Thank you, Mr. Chairman.
Thank you. Is there any questions? Seeing none, thank you very much, Amy. And next we have Mr. Brian Davis, Davis Retail Liquor. Brian, are you online? Mr. Davis?
Yeah, sorry about that. Sorry, I was a little confused. I was supposed to be on this one also. I'm very sorry and kind of embarrassed right now. I want to thank you guys for allowing me to talk to you again. The residency requirement has been great for us to keep the larger big box stores out of the state of Kansas. But like Amy said, with the changes in the laws with Tennessee, and again, Debbie Beaver saying we're open for a lot of exposure to get sued by multiple sides. And we agree that making the change in the laws is the best thing that we need to do. Again, I appreciate you allowing us to be here today to have the conversation. If you have any questions, I'll be here to answer them. Thank you.
Thank you, Brian. Is there any other questions for Brian? Seeing none, thank you very much. We also have written from John Goodyear, Staff Attorney for League of Kansas Municipalities, Elizabeth Patton, American for Prosperities, and Jeffrey Redfern, Attorney for Institute of Justice. Is there any other questions? Seeing none, that will close the hearing on House Bill 2212. And thank you very much for your indulgence today. We had a large group of bills to work through. Tomorrow, we will have hearings on Senate Bill 292 and Senate Bill 293. So with that, this meeting is adjourned. Thank you.